Hi, so my name is Diana Yu. I'm a 2L and I'm one of the co-presidents of the Criminal Law Society, and I'm very pleased to welcome you to Fisher v. Fisher, the Confrontation. We have our two wonderful debaters, Professor George Fisher and Professor Jeff Fisher, and the debate is going to be moderated by Professor David Sklansky. I'm going to be giving a very brief introduction for Professor Sklansky, and then we'll kick it over to our debaters. So Professor Sklansky is, I'm sure many of you have had him for your 1L criminal law class. He teaches criminal law and evidence. A prolific author, he has published papers on such diverse topics ranging from policing, the role of race in the criminal justice system, prosecutors, and the Confrontation Clause. Prior to coming to Stanford, he taught at both Berkeley Law School and UCLA. And before becoming a law professor, he was an assistant U.S. attorney in Southern California. So can you please join me in giving our panelists a warm round of applause again?
So thanks, Diana, and thanks to all of you for coming out for the confrontation, the hearsay melee, the brawl in the lecture hall, the smackdown in Crown. The brouhaha at the School of Law. That's all I have. All kidding aside, I do want to thank the Criminal Law Society, Diana, and Danny Crane for organizing this event and for inviting me to participate. I think it's going to be a fascinating and enlightening hour. It really can't help be anything but that, given the two great legal thinkers who are up here with me. Professor Jeff Fisher, as most of you know, is one of the most successful Supreme Court advocates in the country. We're very fortunate to have him here co-directing our Supreme Court clinic at Stanford. Among the many cases that Jeff has won at the Supreme Court are Crawford versus Washington, the 2004 decision that radically reinterpreted the Confrontation Clause and set the framework for all subsequent confrontation cases. Melendez-Diaz versus Washington, a 2009 case about the reach and proper application of Crawford versus Washington, and Bullcoming versus New Mexico, a 2011 case about the reach and proper application of Crawford versus Washington and Melendez-Diaz versus Massachusetts. Jeff also argued two other confrontation cases before the Supreme Court with less success, Davis versus Washington, which was decided in 2006, and Ohio versus Clark, which was decided last year. Before joining the SLS faculty, Jeff was in private practice in Washington State. Professor George Fisher, as most of you know, is one of this law school's most respected scholars and one of its most beloved teachers. George wrote two of the most influential studies published over the last couple of decades on the history of criminal adjudication in the United States. The Jury's Rise as Lie Detector, which was a book in the form of a Yale Law Journal article, and Plea Bargaining's Triumph, which was a Yale Law Journal article and then an actual book. George has won the law school's John Bingham Hubert Award for Excellence in Teaching, not just once, but 4 times. Before becoming a law professor, George was a state prosecutor in Massachusetts. So Jeff Fisher is one of the architects and chief advocates of the Crawford Doctrine that has governed the Supreme Court's interpretation of the Confrontation Clause over the last 12 years. And George's most recent article is entitled "The Crawford Debacle." So we have stuff to discuss, and I want to get back to George's article and why he gave it that title. But first, I thought I should provide a little background about the Confrontation Clause and its interpretation before and after Crawford, for any of you who may not be as obsessed with this stuff as the three of us up here are. So here's the basic story. The Confrontation Clause of the Sixth Amendment provides that every criminal defendant has the right to be confronted with the witnesses against him. The major question about the Confrontation Clause for the last century has been under what circumstances the clause prohibits prosecution from introducing hearsay evidence against a criminal defendant. Now, if you haven't taken evidence, you might ask, what is hearsay evidence? And all I can say is you really need to take evidence. That's a story in its own right. But back to the Confrontation Clause. When I took evidence in law school, I don't think we spent more than half a lecture on the Confrontation Clause, because what the Supreme Court used to say about the Confrontation Clause before Jeff successfully argued Crawford versus Washington was that the clause barred the government from introducing unreliable hearsay against a criminal defendant, only unreliable hearsay. That was the rule laid down in a 1980 case called Ohio versus Roberts. That case also made clear that one way the government could show that hearsay was reliable and therefore that the Confrontation Clause allowed it was by showing that it fell within a firmly established exception to the hearsay rule. And there are roughly 1 million exceptions to the hearsay rule. In the Federal Rule of Evidence codifies about 3 dozen of them. And the Supreme Court eventually said that practically all of those exceptions are firmly rooted. So if something wasn't barred by the hearsay rule, it wasn't barred by the Confrontation Clause, which was why we could spend only half a class on it when I took evidence. That struck a lot of people, though, as very weird and unsatisfying. Why should a constitutional guarantee be hemmed in by what are essentially statutory exceptions? And when hearsay didn't fall within a firmly rooted exception to the hearsay rule, courts often thought that the Confrontation Clause didn't apply anyway because the hearsay was reliable for some other reason. And reliability struck a lot of people as a very mushy way to apply the confrontation guarantee. So in 2004, a quarter century after deciding Ohio versus Roberts, the Supreme Court listened to Jeff Fisher and changed the way it interpreted the Confrontation Clause. In an opinion by Justice Scalia, the Supreme Court said in Crawford versus Washington that as a general matter, the Confrontation Clause bars all testimonial hearsay offered against a criminal defendant. Crawford didn't define testimonial exactly, but the general idea was that the Confrontation Clause prohibits prosecutors from relying on statements made outside of court by witnesses that the defendant doesn't get to cross-examine if the statements were intended to or functioned as substitutes for in-court testimony. So statements made to the police during a station house interrogation count as testimonial. Actually, the court made that much clear in Crawford. And in later cases, several of which Jeff argued and several of which featured majority opinions by Justice Scalia, the court continued to clarify what it meant by testimonial. It said that statements to the police outside of an interrogation are testimonial if the primary purpose is to establish facts used in later court proceedings. They're not testimonial if the primary purpose is to get the police to respond to an ongoing emergency. Statements in a lab report by a forensic chemist are generally testimonial. And statements by a small child reporting physical or sexual abuse to a school teacher generally are not testimonial, even if state law requires that the teachers report what they've heard about abuse. So that last bit was what the Supreme Court held last spring in Ohio versus Clark. And Justice Scalia joined in that holding, but he wrote separately to complain that the majority opinion shoveled fresh dirt upon the Sixth Amendment right of confrontation so recently rescued from the grave in Crawford versus Washington. And I don't have to tell you that those aren't my words, those are Justice Scalia's words. In particular, Justice Scalia suggested that the majority opinion in Ohio versus Clark, written by Justice Alito, was the first step in an attempt to smuggle long-standing hearsay exceptions back into the Confrontation Clause and to return to Ohio versus Roberts. Justice Scalia said that Justice Alito's opinion seemed aggressively hostile to Crawford, even while purporting to apply it. And part of what got Justice Scalia so exercised, and Justice Ginsburg, who joined Justice Scalia's opinion, was the suggestion in Justice Alito's opinion for the majority in Ohio versus Clark that in determining whether a statement is testimonial, quote, standard rules of hearsay designed to identify some statements as reliable will be relevant. That language was adopted from a case decided in 2011, Michigan versus Bryant, where the Supreme Court concluded that a particular statement made to the police was not testimonial. And Justice Scalia, dissenting, said that the majority was leaving Confrontation Clause jurisprudence in, quote, a shambles. So now Justice Scalia is gone, and whoever replaces him, if anyone ever replaces him, Many people share the worries that Justice Scalia voiced about how committed the court remains to Crawford. But some other people aren't sure that Crawford set us on a very sound course to begin with. So that's what we're going to be discussing today. I have some questions for George, some questions for Jeff. I'm hoping that we'll have time at the end for some questions from you. But George, let me start with you. So has Crawford been a debacle? And if so, in what way?
Thanks for that. Thank you all for coming. It's great to see such a turnout for this event. And David, that was an amazing introduction to the topic. That was really tremendous. We should stop here and go home. It's going to go downhill from here. So before I say one word against Crawford, I do want to acknowledge what Jeff did in Crawford, because this was his first Supreme Court case, handled, I believe, pro bono. He succeeded, first of all, in getting the court to grant cert. I checked the numbers, 8,255 cert petitions in that year. 76 were granted, one of them Jeff's. So that was an amazing accomplishment in itself. And then he persuaded 7 justices of the court to overturn a quarter century of case law in adopting the whole new framework that was embraced by Crawford. My gripe against Crawford is this ahistorical and nonsensical line it draws between testimonial and non-testimonial hearsay, a line that exposes criminal defendants to the risk of admission against them of the rankest, most unreliable forms of hearsay, while stripping them of the right to cross-examine the makers of those statements. And a case in point then is Ohio versus Clark, decided 10 months ago, where the court decided unanimously that a 3.5-year-old child, or presumably any child less than 3.5 years old, in any context, cannot make a testimonial statement. That's effectively the reasoning of the court. The court, 8 justices said a child of that age is too young to understand the potential prosecutorial purpose of the child's statements. So no matter how unreliable the child's statement may be, and the 9th justice, Justice Thomas, said it really doesn't matter what's going on in the child's mind as long as the child's not speaking in the course of structured police interrogation. Nothing the child says can amount to a testimonial statement. So all 9 justices held that this 3.5-year-old child's statement that was at issue in Clark could come in without any chance of the defendant to cross-examine the child, even if the reason that the child does not testify is the judge's determination that the child was too young to form a just impression of the facts or to relate them truly. Even if all that's true, the statement, no matter how frankly and obviously unreliable, can be admitted without any chance on the defendant's part to cross-examine the accuser. Now, I know because Jeff litigated the case that he will argue, and I'll stop just a moment, but that he'll argue that this was a misapplication of Crawford. But I suggest this isn't Jeff's Frankenstein gone rogue. This is the monster behaving as the monster was programmed to behave. This was a faithful, I'll argue, but I'll wait till later, a faithful application of the Crawford doctrine. It was Crawford come home to roost.
So is that right, do you think, Jeff?
Do I get provided? Well, thanks. And, let me start before anything else by just one more time reiterating what a fun event this is and thanking the Criminal Law Society for putting it together. It's neat to have the enthusiasm in the room to hear about this stuff. And George and I have had many versions of this conversation in private, and it's neat to be able to do it in a setting where you all can share in the fun. So let me say a couple things in responding to the initial critique that George laid out. I want to make 2 particular points. Before I do that, I just want to say one word, maybe I'll say more later, but one word in defense of Crawford and where it comes from. George characterized Crawford as being an ahistorical and I think new approach to the Confrontation Clause. The way that I've always conceived it is it's a return to the historical understanding of the right to confrontation that we temporarily departed from starting in the 70s, then crystallized in 1980 in Ohio versus Roberts. So even though the court didn't necessarily use the word testimonial, when it was deciding cases before the incorporation of the Confrontation Clause against the states in the late 60s and 70s. That was the idea behind the common law right and the way the court itself decided all of the cases. And the reason why I think it's a historical and fair understanding of the confrontation right starts with the text of the Sixth Amendment, which, as David said, says the defendants have the right to be confronted with all the witnesses against them. So what we're trying to ask is not whether hearsay is unreliable. We're trying to ask whether somebody is a witness. And my definition of a witness is somebody who gives testimony. And so that's where the word testimonial comes from, is that the Sixth Amendment gives the defendant a right, obviously, for any person who's in the courtroom testifying against them to cross-examine and have the other basic requirements of confrontation satisfied. And then it has to have an exclusionary rule that keeps out of-court statements that would unduly impair that procedural constitutional right inside the courtroom. And that's what Crawford does. And so I approach this kind of as a criminal procedure question, perhaps more than an evidence question. But we can get more into that later. I'm happy to, but just I hope that sets the stage for my couple of comments about Clark. And I'm not exactly going to say what you might have thought I would say. I mean, I think Clark was a very hard case. And one thing I should mention is that Clark was a case we did in our clinic, as with some of these other cases. So while you guys are being nice and heaping some praise on me, it's really the students in the clinic who've litigated a lot of these cases and done fantastic jobs, win or lose. Ohio against Clark was a very hard case on the facts. I think it was arrested, I'll just say right now, somewhat at the borderline. And maybe the majority of opinion is actually fully defensible. But the two things I would say in defense of Crawford, nonetheless, let's assume Clark comes out correct. Two things I would say is, number one, is that I do think George, even though George, if he were a judge, might have kept that statement out under the Roberts framework, he would be the only judge in 1,000 that would have kept that statement out, as far as my understanding of the way the Roberts framework was implemented across the country. I know there's a U.S. Supreme Court case versus Idaho called Idaho against Wright that was decided under the Roberts era, where they actually kept out a child statement, roughly analogous perhaps. But if you shepherdize Idaho against Wright, you will find just an entire slew of lower court precedent, always distinguishing the case, always admitting the child statement, always deeming the child statement reliable, because judges did not want to keep these kind of statements out. And indeed, state legislatures across the country drafted statutes like Ohio's that were all specifically designed to let these statements in. And that's how we got to the problem in Ohio against Clark to begin with. And so then that leaves you with the question, well, if neither doctrine keeps it out, which is the better doctrine? And I think Crawford is the sounder doctrine because it's just sounder for all the reasons hopefully we'll get to discuss. And I would just say, just because I agree with George on one point, which is I do agree this is a totally unfair trial that Mr. Clark had to endure, both in terms of the statement's unreliability and even more so compounded by the fact that the reason the child can't testify is, as George says, because a court has otherwise deemed the child incapable of relating true events. But that seems to me a problem that state law and state hearsay law ought to be solving, maybe the due process clause, but just because something is a really bad idea doesn't necessarily mean the Constitution bars it, or the Confrontation Clause more specifically bars it. I just think state hearsay law ought to be taking care of that problem, not the Constitution.
So George, you said your two major bones to pick with Crawford were that it was ahistorical and nonsensical. So what's ahistorical about it and what's nonsensical, particularly if the alternative is Roberts, which Jeff says is toothless?
Okay, so all 3 points, ahistorical, nonsensical, and toothlessness of Roberts. Ahistorical, so Jeff said a moment ago my definition of a witness is someone who testifies. Now, Justice Scalia, in writing Crawford, said my definition of a witness is someone who testifies, but the way he derived that, because you know that Justice Scalia was an originalist, and so not somebody who would ever fess up to reaching into his own mind for the definition of an important constitutional word, was to, his approach was to pick up an 1828 edition of Webster's Dictionary, which gave 5 definitions of witness, Justice Scalia landed on the fifth, which said one who gives testimony. So then he incorporated into the Sixth Amendment, which does not use the word testimony, this notion that only those people are subject to a defendant's right of cross-examination who give testimony, which then eliminates a whole swath of potential hearsay from even coming within the realm of the kinds of statements that would give a defendant the right to cross-examine their maker. Along the way to getting to definition 5, Justice Scalia skipped over some other definitions that clearly wouldn't have applied in this context, but including one that does. The third definition in that same Webster's dictionary, which said, one who knows or sees anything, i.e. an eyewitness, all of that within the definition. Now, we would all think of ourselves as witnesses, I think. If we saw a crime, we became an eyewitness, we would think, I'm a witness, and that would not turn on whether we ever also gave evidence in court. But if we spoke to, if you spoke to your sister and said, hey, here's this way the shooting just went down that I saw, and your sister then went into court and repeated your words, you might think that you are now a witness against the defendant because you're under this Webster's definition. You're one who saw or knows something. Your words were being repeated in court against the defendant, and that might create a right on the defendant's part to cross-examine you. I would think that would be perfectly right, but not under Crawford. Because under Crawford, if you talk to your sister, you're not doing anything like giving testimony. And so your words can be repeated by your sister in court willy-nilly without giving the defendant any right to cross-examine you. And it would be nice if Justice Scalia could point to anywhere else in the common law of hearsay or of the Confrontation Clause where somebody drew a line between testimonial and non-testimonial hearsay. But the words never enter the legal argot at all until the 20th century, a couple centuries after, at least a full solid century after the framing of the Sixth Amendment. There's no common law precedent for dividing the hearsay world to testimonial and non-testimonial hearsay. There's no notion that at the time of the framing, those who made non-testimonial statements of the sort I mentioned a moment ago would make statements that were then admitted against defendants at trial without creating a right on the part of the defendant to cross-examine their maker. So that's the ahistorical part. Let me just skip to the amorphousness part, the part that suggests that the reliability standard is infinitely malleable. It's a little hard to tell from appellate rulings because you don't get to an appellate ruling in criminal procedure unless the defendant has lost below. So there's no way of knowing how many trial judges were under the Roberts regime keeping out hearsay statements as unreliable because the prosecution has no right to appeal in criminal procedure except in very narrow circumstances. And so we never get appellate rulings where the trial judge kept out a statement under Roberts. You always begin with the appellate ruling admitting the statement at the trial level, and then the defendant attacks that ruling. So it's not terribly surprising that the prosecution typically won on appeal, because if the trial judge was doing right, and the trial judge was making decent rulings at the trial level, and I don't know of any study looking at the rulings under Roberts at the trial level to see with what degree of fidelity judges were keeping out unreliable statements. But it still wasn't a toothless standard. Take the statement at issue in Ohio versus Clark. The trial judge made a rather perverse judgment under Ohio hearsay law, and Jeff would say this is evidence on his behalf, that the statement could come in because Ohio hearsay law required it to be reliable. And this was not a reliable statement. A teacher looked at a child who was bearing obvious signs of abuse and said, quote unquote, who did this? The child answered in 2 monosyllables, D. That's as much as the child said. This name D was apparently the nickname of Darius Clark, the defendant. And on that basis, the defendant was tried, convicted of beating not only the 3.5-year-old child who made this statement, but that child's younger sister, sentenced to 28 years in prison. This is not, even the teacher actually testified at trial that the child, when he said D, looked bewildered and seemed uncertain. So that was a perverse ruling on the part of the trial judge. And it does suggest that a trial judge who's bent on admitting a statement can find it reliable. But that judge was reversed on a very similar ruling with regard to the same child's statements to some other witnesses on appeal by the Ohio Court of Appeals on that very question about the reliability of the hearsay. So it's not a toothless standard. And I think that almost anybody in this room, as trial judge, asked, is this a reliable bit of hearsay, would keep it out. Unless you think of yourselves as being so easily swayed by prosecutorial argument that you would let that one in. I just don't think that this is a toothless standard. I'll come back to the nonsensical point. I've talked long enough. But
So, Jeff, George says that there was no common law tradition of distinguishing testimonial from non-testimonial hearsay. Is that right?
Yeah, I'll answer that, and then I'd say a word about the amorphousness.
Yeah.
No, I don't think that is right. I fear we might drain the enthusiasm in the room if we started to toss 17th century common law cases back and forth. I will certainly concede, as I did earlier, that the word testimonial is rarely used in the old cases. But you do, and if anybody cares enough to look, my Crawford brief itself spent several pages trying to trace the history in England, and then as it was brought over to this country, and cases on both sides of the line. And what you found is rhetoric and court decisions saying, this statement is inadmissible because the defendant has the right to be confronted with, has the right to confront the witnesses. And so the word testimonial wouldn't be used, but if you find the cases that you reasonably think are being decided on confrontation grounds and then sort them out, they do sort, my contention is, pretty well in that respect. And so if anyone wants to read literature, both in my brief and then later literature, I think debates that to some degree. The other piece of the George's history argument is the word witness, and Justice Scalia's selection of a particular word in witness. And I think this is really an important point because it goes to two different ways of viewing the confrontation right, and perhaps a distinction between George and I, is that I think the word witness in the Confrontation Clause is describing literally only the people who go into court and testify. And so the defendant, so it's setting out a rule of criminal procedure. It's not a rule of evidence. There's no rules of evidence in the Sixth Amendment. It's a rule of criminal procedure that says the way the prosecution introduces its testimony is in contrast to continental Europe, is by bringing the witnesses into court, having them testify under oath, subject to cross-examination in the presence of the defendant. That was the English method that we adopted in the Sixth Amendment. And so that's what the word witness means. Then you have the subsequent question, well, how do you enforce that right? Does it mean that as long as the prosecution doesn't bring the witness actually into the courtroom, the defendant has no rights whatsoever? So that if they get their colleague to do videotape a Q&A outside the courtroom the day before, they can just play that to the jury and say, oh, sorry, no right to confrontation, the witness isn't here. I think everybody would understand that would be unacceptable, so then what you have to have is an exclusionary rule that says which out-of-court statements so threaten that procedural right the defendant has that they need to be kept out. And so the kind of statements I think satisfy that test for an exclusionary rule are ones that are so witness-like, so testimonial, that they need to be excluded. And I totally agree, and maybe we'll talk about this more, the word testimonial itself, even if you agree with me that far, is hardly self-defining. There are hard cases on either side of the line, and we can talk about the fact that, I agree it's a hard standard to employ in some borderline cases, but I don't think that undermines the standard. And I think the only other thing I would like to add, and then I'll let David move the conversation on, or George make a rebuttal if he likes, is that I just wish George was a trial judge all the more when I hear him talk about how Roberts should be employed. I speak regularly to criminal defense groups. I go around, the country and hear state by state and in national meetings. I mean, Clark was an absolutely routine application of state hearsay law and the way Roberts would have been applied in that case. People would laugh at the notion that should be, and people actually put it the other way around. People were shocked at the Ohio Court of Appeals suggesting that statement was unreliable, although only some of them, not all of them, which is how we end up where we are. Often courts would say, well, that one statement was unreliable, but the prosecution is still allowed to use the other statement that says about the same thing to get the conviction. So whether you call that legal realism or whether you call it just the amorphousness of the standard, my understanding from talking to lawyers across the country is that the way the standard was implemented virtually gave them nothing.
So you don't think, Jeff, then, that the decision in Clark suggests that the Crawford doctrine is in trouble or that the monster has come home to roost?
Yeah.
You think the doctrine's in good shape?
Well, I think those are two different questions, so start with the whether it's in trouble question. I do think that the author of that opinion, Justice Alito, would very much like to overturn Crawford. And I think that it's one of those instances where he's trying to take a few jabs, which is what gets up Justice Scalia's dander at the decision. So I do think there are, at least one and perhaps more justices on the court with certainly with some displeasure in Crawford. In asking whether the case is really in trouble, I want to answer it in two parts and divide the universe between what Justice Kennedy has called conventional witnesses, which are eyewitnesses that then we argue, people who make eyewitness-type statements outside the courtroom, and then victims or other eyewitnesses, and then we get into fights about whether the right to confrontation applies. Put that in one bucket. I'm not sure I love the term conventional witnesses, but that's the term that Justice Kennedy has used. And then you have the forensic analysts that are at issue in Melendez-Diaz and Bullcoming, which we may talk about more later, but for present purposes, it's easy to understand just those cases hold essentially that a forensic analyst needs to come into court and defend his study rather than just send it in an affidavit. There are, I think, 4 justices that have quite a bit of displeasure with the forensic evidence cases, and maybe even to the point of being willing to look at overturning them, depending on who the next justice on the Supreme Court turns out to be. I do think that the conventional witness side of Crawford is quite secure, and then the debate there simply is whether or not, how broadly or narrowly you read the word testimonial. So Justice Alito would take a very crabbed approach to the word testimonial, whereas Justice Ginsburg and perhaps some others would take a broader. So that would be my take, but just to reiterate, the next justice on the court is going to potentially have a lot of impact, at least for part of Crawford, if not for a lot of it, which is one of the fun things about this whole topic in general, is that when Justice Scalia steps away, or passes away, unfortunately, there are many people in the civil rights community on the left and who say, oh, great, now we get to put somebody else new on the court. Well, for those of us that care about criminal justice, at least in certain areas, we could be looking at a step backwards, depending on who we get.
So, George, is that your assessment of how secure the doctrine is at this point also?
Well, I think the doctrine's actually really in trouble. I mean, I think that 4 justices have been bent on overruling Crawford since Melendez-Diaz. Now, Jeff is right that in Melendez-Diaz, a case that concerned the admissibility of a certificate that a chemist had produced after doing some analysis on some white powder and saying it was cocaine, 4 justices cleaved from the majority holding, saying that was a testimonial statement. I think the holding was right, that this clearly was a testimonial statement under Crawford, and yet 4 justices managed to dissent, and they dissented, as Jeff said, under Justice Kennedy's authorship, saying there's a distinction we can draw between a conventional witness and a laboratory analyst. I think that distinction was wholly spurious and was a really bad bid on Justice Kennedy's part. As much as I was in sympathy with this idea of cleaving from Crawford, I thought that was a really bad distinction to try to draw, but they've abandoned it. Bullcoming, 2 years later, considered another laboratory analyst's certificate, this one not of white powder, but of blood. It was effectively a replay of the exact same case.
It wasn't a certificate, though, remember. That was with Justice Thomas.
Yeah, there was do we call this a certificate or not? But it was a piece of paper that the analyst had produced. But it was really a replay of Melendez-Diaz. And the court cleaved exactly the same way. But this time the word conventional did not appear in Justice Kennedy's dissenting opinion. It was the same case all over again. He dropped that bid. Williams, Illinois v. Williams, which came up yet a couple years later, concerned another laboratory analyst piece of paper, which this time dealt with DNA analysis of a semen stain. And again, Justice Kennedy is on, and Justice Alito this time writing, on the side of the court that's letting the statement in. And again, no appearance of this word conventional. So I think that it's just gone, I think. And I think with one more vote to undo Crawford, I think there are 4. And I think it's completely unpredictable whether Justice Garland would be that 5th vote or not.
You want to speculate about that? I will not speculate.
All right. Well, then I want to come back to a point you made earlier, Jeff, when you said that you think of Crawford as really a rule of criminal procedure, not as a rule of evidence. And I guess it's hard for me to understand how you can characterize it like that in a case where the witness is dead or otherwise unavailable, because and those are the cases that, in many ways, are the hardest cases. Some of the most controversial cases involving application of Crawford have to do with situations where, say, there's been a murder and the victim said something before she was killed, and now there's a question about whether the jury should be allowed to hear that evidence, and the Supreme Court says, often the answer will be no. Yeah. And it seems to me it's hard to view that as anything but a decision about admissibility of evidence. And I guess I'd say also, just so that you have enough to keep you going, if we're having to figure out whether to allow in a statement by somebody who now is dead or for some other reason can't testify, doesn't it sort of make sense that what you'd want to know is, well, how reliable is that statement? Why would instead you want to know whether that statement is testimonial?
Okay, great. So to start with the question what exactly I mean by calling this a criminal procedure rule instead of an evidence rule, there's no doubt, and I completely agree, that on one level these cases are about the admissibility of evidence, and therefore there's an evidence question if you want to, if whenever you're talking about whether evidence gets put into a criminal case or not, on one level that is an evidence question. But let me give you a comparison. I mean, think about defendants' confessions. We have lots of cases about whether defendants' confessions are admissible or not, and we teach them in criminal procedure. We don't, I think, I haven't looked at your syllabi, but I think that generally that is handled in criminal procedure, not evidence class. And so one is as much an evidence question as the other, in my mind. I mean, they both deal with the admissibility of a statement made outside the courtroom. But to my mind, they also both deal with a set of questions we ask about whether admitting that statement is going to unduly impair some procedural right the defendant has about the way he's tried. So the Fifth Amendment right against self-incrimination is a rule about when the defendant is a witness, and the Confrontation Clause is the rule about prosecution witnesses. And so I don't want to get too hung up on the labels, but that's my approach to the question. So then you also asked about the case when a witness is dead or otherwise indisputably unavailable. And obviously that's where the hard questions arise, at least in terms of consequences and bite in terms of the rule. So first of all, I don't disagree that a sensible legal system would ask whether that statement is reliable. And again, that's why we have hearsay law. That's why hearsay law has developed. I just don't happen to think that's what the Sixth Amendment confrontation right is putting in our Constitution. There are lots of great, sensible legal rules in the world that aren't in our Constitution. When I look at the text and the history of the right to confrontation, it seems to me to be talking about the stuff I've talked about already. And so then I guess the question is, why should we care about that? Why is that so important? And I think it goes back to the roots of the civil law method that we rejected and the English method we adopted, which was the idea that openness of procedure, and which is, remember, not just cross-examination, which is in a sense the Johnny-come-lately to the confrontation right. It's the testifying face-to-face with the defendant for the jury to observe the witness and those sorts of things, which are somewhat overlapping with hearsay. I mean, I can imagine you coming back at me with that. But there's a history of open procedure in the courtroom and a particular method of giving testimony that the Constitution decided to specially protect. And so that's why I think we ask one set of questions on the confrontation right and a different set of questions as to hearsay law.
Does that make sense to you, George?
Well, I don't agree, but not surprisingly. So I totally agree about the importance of the cross-examination right. And but just when focusing on the areas of the law where we're giving the defendant that right, and I think we need to focus on the areas of either of these two regimes where we're not giving the defendant that right. And that's why I started out talking about Ohio versus Clark in the case where the court effectively held if a child is 3.5 years old or younger, then anything the child says out of court can come in against a criminal defendant without there being a right to cross-examine. And that's why when I look at the history, I'm looking to see if there's historical precedent for saying with regard to an out-of-court hearsay statement, this one isn't testimonial, and therefore it can come in against criminal defendants without creating a right to cross-examine. Just right that you can find lots of statements where courts said this kind of statement does create a right of cross-examination if it comes in against criminal defendants. But the theory of Crawford is that there's a whole realm of hearsay called non-testimonial hearsay that can come in against criminal defendants without creating a right to cross-examine. And that's the part that I think has no common law rooting, and that is not sensible. So let's go back to what's sensible and what's not here with regard to where we draw the line. If we focus on when we're going to not let criminal defendants cross-examine the makers of the statement, Crawford and those who follow Crawford say we should define this class of non-testimonial statements where testimonial statements are typically defined as those where the maker of the statement anticipates the prosecutorial use of the statement later. And so therefore Crawford suggested if the maker of the statement, such as a 3.5-year-old kid, can't anticipate the prosecutorial use or didn't anticipate the prosecutorial use of the statement, then there should be no right of the defendant to cross-examine that person. And then you say, well, why? Why is that line drawn there? This is the part I find nonsensical. What is it about a person's statement made without the anticipation that it will be used by a prosecutor at trial that means that it should be able to come in against a criminal defendant without creating a right to cross-examine the maker of that statement? And the only answer that I can think of to that question that feels like it makes sense is one that says that a person who speaks in anticipation of the prosecutorial use of the statement has a reason to lie, just as a witness at trial might have a reason to lie because you understand that your statement could be used against somebody and you might have a grudge against that person. But that's an argument rooted in reliability. And that just brings us back to the question that David asked Jeff, which is, why don't we just draw the line according to whether the statement is reliable or not, which means we can ask in any particular case, if we can't cross-examine the maker of the statement, might we want to let it in anyway because it is so apparently reliable? So let's just distinguish between the child statement in Clark that I described and this other, forgive the language here, but I do want to just make the point that you can imagine a 3.5-year-old child's statement about abuse that seems really reliable. So the 3.5-year-old is playing at daddy's feet at dinner time. Daddy's making dinner, and the child out of nowhere says, "Daddy, does milk come out of your penis?" And daddy says, "Why?" And the child says, "Because it comes out of Melanie's dad's penis, and it tastes yucky." Now, wouldn't you want that statement to come in? And wouldn't you feel as though, unlike the statement, the monosyllables I mentioned earlier, D, that statement feels like one, well, if we kept that out and this guy goes free, have we really advanced the case? And is that what the Constitution meant to do when it guaranteed the right to cross-examine witnesses against someone? Or did maybe the framers anticipate that some statements, such as dying declarations, which came in at the time of the founding, and business records, which came in at the time of the founding, might be so apparently reliable in certain circumstances that we don't want to keep them out when there's not a chance to cross-examine the defendant?
So, Jeff, it's one thing to say that the Constitution doesn't do everything. And there may be categories of unreliable evidence that the Constitution doesn't prohibit. And that's not a knock on the Constitution. That's not what the Constitution set up to do. That's why we have evidence law. But it's another thing to say that there's evidence that we want to allow in, that the Constitution's we're gonna interpret the Constitution in a way to preclude. And I guess that's really where George was going, and I'm still unsure why you think it's is it just that history requires that we interpret the Constitution in that way? And if history doesn't require it, why would you want to interpret the Constitution to bar statements from unavailable witnesses only if those witnesses seemed testimonial, as opposed to only if it seems unreliable?
So I think what you're asking me is a slightly different type of a hypo than George was just giving me, because George's hypo wouldn't be a testimonial statement. You're asking me about an out-of-court testimonial statement that is testimonial, that seems reliable, and why would we want to keep that out? Am I tracking your question right? So it's a great question. Again, I think it goes back to the nature of constitutional rights, and forgive me for referring a little bit even to what's in Crawford. So we have other constitutional rights, like right to counsel, right to a jury. They're not very many. It's not a long list. But there's a few things that we say are indispensable for a fair trial. And we don't suspend the right to counsel or the right to self-incrimination or the right to a jury trial when we think that it's really not going to serve any useful purpose in that case. We give those things regardless. And the question is, why do we give those things regardless? And maybe even recognizing when I ask that question that this is maybe a harder case for proving that point. But I think it's because it goes to, and this is where Justice Scalia was appropriately a leader here, it goes to how much you trust judges. I mean, part of what I hear in George is an incredible trust for trial judges to meaningfully impose a reliability standard. But one way to think about the debate that we're having as to what the confrontation looks like, depending on which version of it you adopt, is you either have a very, very wide coverage, but a very shallow constitutional right, where judges, everything comes within the ambit of confrontation, but as long as they can find it reliable, they can suspend the right. I have a much narrower view of confrontation, but is much deeper, and it's more categorical. And so my view is when you actually come within the right, it is too tempting and too problematic from a constitutional law standpoint to leave it to judges on a case-by-case basis, because you are gonna take some strong medicine by occasionally leaving out a very, very reliable statement or a seemingly reliable statement of a eyewitness that then makes the case impossible to prosecute. But that's the cost we pay in the system for keeping out and for closing judges from putting in all the other kind of statements, at least insofar as they're testimonial, that I think George and I would both agree we should worry about.
So George, do you agree that a lot of this comes down to how much you trust judges?
I actually agree with almost everything Jeff just said. But let's imagine a different Roberts framework from the one the court actually wrote in Roberts, but a reliability standard that, as Jeff says, goes deep and goes categorical. So actually, Jeff is not going to take credit for this, but he began the design of such a system in it was 1999 in Lilly versus Virginia, where Jeff was clerking for Justice Stevens, when Stevens wrote an opinion in the last of the Roberts era realm of looking at the reliability of statements. And Stevens began, but had only 4 votes for doing so, an idea, I assume actually that Jeff wrote this opinion, though I don't think he can confirm that, where the issue in that case, just as it was in Crawford, same case, same facts, was a custodial statement by an accomplice that implicated the defendant. And in that case, Justice Stevens said, such statements as a class are unreliable because a custodial accomplice has an interest in making herself or himself a witness on behalf of the prosecution against the defendant, and therefore whatever that custodial accomplice says, somebody in custody making a statement to the police, is going to be unreliable. And as a class, these sorts of statements will be deemed unreliable. No more case-by-case judicial determinations in that class of statement. And you can imagine other classes of statements. Grand jury testimony at the behest of the prosecution without the benefit of cross-examination or even the presence of the defense. We could say, as a class, such statements are unreliable. They should not be admitted in a reliability-based regime. as a class, when a defendant is pleading guilty and makes a plea allocution, and in the course of that allocution implicates somebody else, that as a class, those statements also could be done to curry favor with the authorities and should be deemed unreliable. And you could imagine other such class-based judgments that that would cover a big territory within the hearsay realm, that are all rooted, though, in what I think of as a very, very common sense notion that letting in hearsay without the benefit of the confrontation when it's reliable, but not when it's unreliable, is at least a distinction that makes sense. It's hard for me to make sense of the testimonial, non-testimonial distinction.
Can I say one thing about that? It's really interesting. I won't say anything else about Lilly, other than to note for the audience that after Lilly, there was a study done 5 years later that found still trial courts were quite commonly letting in exactly those kind of statements that the Lilly opinion had been designed to keep out. But there's another layer, just to show everybody in the room how difficult and complicated this is, and how legal ideas circle around. Let me take George's notion and actually transport it back in time about 40 more years, because that's exactly the set of arguments that George just described that the criminal defense bar was making after Roberts. The criminal defense bar took Roberts and said, aha, any statement that's unreliable, that cross-examination might make some difference about, we can now keep out under the Confrontation Clause. And criminal defense bar went wild at the thought of Roberts, and they thought, this is going to be great. And so in the decade or so that followed Roberts, the prosecution kept fighting against the doctrine, to the point where in 1992, in White against Illinois, there was another case about a child statement. And the U.S. Solicitor General's office came in as amici in the case and filed a brief in the U.S. Supreme Court saying, you know what, Roberts is really wrong. The Confrontation Clause doesn't cover all hearsay evidence. It just covers a special kind of testimonial hearsay. By the way, a little footnote in history. Do you know who one of the authors of that brief was in the U.S. Solicitor General's office? Samuel Alito. So in other words, when the argument was made that George just described, the prosecution and the governments across the country recoiled and fought the courts, but actually they didn't win the way they wanted to win. What they wanted to do was to create something kind of like Crawford. But instead what courts did is water down the reliability standard to virtually nothing. And so by the time Crawford came around, 10, 12 years later, everything was flipped, and the criminal defense bar wanted to get rid of Roberts, and the prosecution wanted to keep Roberts because it had been watered down to almost nothing. So maybe theoretically you could have the system you described, but we've been through this once already before.
So George, I want to give you a chance to respond, but first, you all have been very patiently listening, and I did promise that we could have some questions from the audience. So I think
I'll let you have the last word.
Well, Diana has a microphone that she can carry around, and if you catch her eye, she'll come over, and then we can have some questions from some of you. And while Diana's doing that, George, you want to respond?
Okay. Yeah. Just on the point of the study that Jeff mentioned, because Justice Scalia made a lot of that study in Crawford. And it was a study after Lilly, the case I described a moment ago, in cases just like Lilly, what proportion of cases in which trial judges let in custodial statements by an accomplice was there then a reversal on appeal. And Justice Scalia in Crawford, reading the study, said in only 45 out of 70 cases was there a determination of error, meaning that in 25 out of 70 cases there was no determination of error. Although in all such cases, if Lilly had been law, there should have been a determination of error. So what's wrong with that, first of all, is that Lilly wasn't law. It was only 4 justices who subscribed to the opinion that I think Jeff wrote. Had a 5th justice, for example, Justice Scalia, joined, then it would have been law. And then we could ask whether these later lower court judges made mistakes in admitting the kinds of cases that Lilly would have kept out. But even though it wasn't law, appellate courts ruled in 45 out of 70 cases that it was wrong for the lower courts to have let in the statements that just the plurality in Lilly would have kept out. And in 37% of those 70 cases, there was a reversal on appeal. Now, you should all know the reversals on appeal are really rare, usually around 15%. And here we are dealing with a precedent that wasn't even law, and it still triggered reversals in 37% of cases where judges made the wrong ruling. So I think that Justice Scalia made way too much of that study in Crawford.
Well, want me to stop? Yeah.
Sir, questions for any of you?
I'm particularly curious about the child's testimony example that you gave. Carl Sagan in The Demon Haunted World gives a number of examples where children's testimony, such as this, was later proven to be remarkably unreliable, despite it seeming like, well, how else could they have possibly thought of this explanation that they're giving for this? So why would we want to let what we otherwise might be very skeptical of, a child claiming something very serious, why would we want to privilege that type of evidence?
So I think if you wanted to have a really absolutist notion of the Confrontation Clause and say all uncross-examined statements made out of court should be banned, that's what the Confrontation Clause means. I actually wouldn't object. I think that's a reasonably fair reading. The difficulty is you'd run into first of all, some historical precedent, letting in dying declarations, letting in business records, letting in co-conspirator statements. So you do have some common law precedent, even at the time of the founding, that suggesting that that's not what the framers had in mind. What's troubling to me is that now we have an area of law that lets in any statement by a young child, however reliable or unreliable. That's where we now stand after Clark. I won't lie in the tracks saying that every statement that the trial judge might deem reliable really is. But the notion behind letting in evidence at trial is, are we advancing the cause for truth, the search for truth? And yes, it's ideal if we can give the defendant the right to cross-examine the maker of a statement. Where that's not available, where that's not possible, as in the case of a 3.5-year-old child, are we advancing justice more by keeping the statement out or by letting in? I happen to think that when a statement seems on its face, and given all the circumstances in which it was made, to be strongly reliable, that we should let it in. Do I insist that such a statement necessarily is reliable? No, I don't think that would be realistically a reading of what goes on in courts today. We could keep out all such statements, but I think that we would not get closer to justice doing so. But I could see reasonable people differing on how that line should be drawn.
I had a question about just kind of if you're looking at like the net effect of whether it was kind of a return to a reliability standard or if we stuck with Crawford, because it seems to me that if Roberts or whatever might replace it is essentially coextensive with what is essentially state hearsay rules and federal hearsay rules, that there isn't those kind of just map onto each other and that's all that you keep out or let in. But with Crawford, there's a little bit of extra space on the Venn diagram for something that, yes, is reliable, but is testimonial, and that would provide some additional things that are kept out. And I'm wondering, I guess this is maybe more directed at Professor George, I guess I should say, is that seems to me that at least if you're looking at the net effect of how much is coming in, that Crawford keeps out more than Roberts would, because with Crawford you have the constitutional bar and then of course the the statutory bars. And the only difference I can see between those two regimes and this kind of net effect, reasoning is it either going to be the state Supreme Court having final word on what the state, laws mean for most of these criminal cases, or is it going to be the Supreme Court who gets to kind of be the final arbiter of what reliability means? Is that distinction enough to make this really worth our while, or is there something maybe that I'm missing where a reliability standard would do something that Crawford doesn't, as far as keeping statements out?
Okay, fair question. I don't advocate a return to Roberts per se, because I do think Roberts was wrong in saying that we can assume without asking anything more that a statement is reliable if it fits within a firmly rooted hearsay exception. A lot of the hearsay exceptions, I think we can say, let in a whole bunch of stuff that we wouldn't say was constitutionally reliable to the extent that where we're comfortable depriving a defendant of the right to cross-examine the accuser. I think, though, that the two regimes are very parallel in the sense that they each look at the regime I imagine Roberts, or revived Roberts, could be, where you have categorical judgments that say this sort of statement is just categorically unreliable, such as these custodial statements of an accomplice. Roberts has been, the Crawford case law has been making such categorical judgments as well. So, for example, Statements made by laboratory analysts are categorically testimonial. So the question is, which set of categorical judgments are we more comfortable with? The ones that draw the line according to testimonial, non-testimonial, or the ones that draw the line according to reliable, non-reliable? I could imagine dividing the world of laboratory technicians into those who are creating reliable statements of work from those who aren't. Say, for example, if somebody's working for the government, that's a count suggesting unreliability. If somebody knows what answer the prosecution wants when the prosecution submits a baggie of white powder and then says, yes, this is cocaine, or yes, this is heroin, or whatever, that's a count of suggesting unreliability. So that in that sense, I would say this Melendez-Diaz and Bull Cumming are really producing the same results that we would get in a revived Roberts regime. But you can imagine some laboratory analysts, for example, analyzing a DNA sample submitted by maybe a criminal defendant who's trying to exonerate himself, maybe a prosecutor trying to convict somebody, having no idea in any event who the suspect is, what the right answer is, simply producing a DNA profile. If that person signs a certificate saying this is the DNA profile I generated from this substance, are we really going to demand that in all cases the prosecutor flies that analyst across the country to testify live? Or might we say that this is a case where that certificate is sufficiently reliable?
The only thing I'd add is that it used to be under Roberts that you got actually a little bit more because you got not only the U.S. Supreme Court overseeing, but you got meaningful opportunity to go and get habeas relief if you thought that the state court had been too loosey-goosey with its standard. But under the amendments to the habeas statutes, that kind of drops away nowadays.
Hi. So let me first thank you for doing this. I wish that you would let us know anytime you're having a conversation. And we can just, have it in 190 and like we're not here. So this has been great. I guess I'll focus my question on Professor Jeff. Do you worry that Crawford might just follow the same erosion track, where the government's default position in an exclusionary rule context is always to try to keep evidence that they like, and there are still a lot of open questions, like whose intent matters,
right.
Is there some sort of proof of that we have to have, is the judge just going to decide? It seems like there's a lot of room for Crawford to erode the same way that Roberts did, but at least Roberts not threat.
Right. So good question. So I do worry about, so yes and no. Yes, I worry about erosion. I worry, I think Michigan against Bryant, which is a case George mentioned quickly, I have a hard time swallowing that case, for example, which is a statement that a shooting victim makes to a police officer who arrives at the scene and says, "Who did this to you?" I think that that's a statement that under a fair reading of at least the theory that we put forward in Crawford, should probably be testimonial. So I worry that decisions like that, and I should say bracketing, perhaps not coincidentally, against the backdrop of the scenario that Professor Sklansky sketched out, where that witness ends up dying, and so it's that or nothing for that prosecution. So I do worry that there's going to be some slippage in Crawford as it eventually gets construed, and whether, even putting aside the membership of the court as it might change. But I do think that it's a sturdier structure than Roberts. I do think that Roberts, or I think even George is not describing something different than Roberts so much as just Roberts with genuine teeth. It's still reliability is the question he's asking. I think that that's time-tested not to have any genuine teeth, and that lets a court let literally anything in. And maybe George would amend that by saying if certain categorical rules were drawn. But boy, my goodness, George, to show how far George is away from even the dissenters on the court, the dissenters in those Melendez-Diaz and Bull Cumming cases are all about reliability. So they're writing exactly the opposite theory that George just described to you about how you would do reliability in that setting. So I think there can be some slippage, but I think things like station house interrogations, interviews by the prosecutor, videotaped testimony to be used as a substitute at trial, affidavits, things like that are really hard, I think, to admit under Crawford. There's definitely a fair amount of hard questions about things like, responding police officers in quasi-forensic settings and things like hospitals and the like. That's where the play in the joints is. But my goal here is to create a doctrine that's at least asking what I think are the right questions, and hopefully a doctrine that at least for the core is going to be solid.
So I think we have time for one more question.
Very Stanford question about the future of the doctrine, I guess, with technological changes. Could you talk about maybe one technological change like greater surveillance or the more automation of the processing of information that I guess for Professor Jeff you think is going to vindicate and strengthen this structure that you've established, and for Professor George that's potentially going to undermine and ruin this doctrine, or open it up for something to replace it, something you see going forward technology-wise?
Well, I'll say a couple quick things that come to mind, and I'd be curious if you have anything in your mind in asking that question that I may not think of. So one thing I get asked, that I've been asked about now and then, are red light cameras. Maybe self-interested questions somebody happens to bring to me, but cameras out there in the world that film an event and then basically serve as all the evidence against you. And so maybe if you flash forward into the future where things like that get a little smarter, and maybe there's printouts that accompany it, and so you have a computer really observing and talking in the robot world of the future. I don't know whether that's for or against Crawford or for or against Roberts, but that seems to me a hard question about how you're going to apply the rule of confrontation. I think there's one other technological question, which is a slightly different subject than we've discussed. We've been talking about which evidence, which statements come within the scope of the clause and which don't. There's another technological question about once you have a statement subject to the clause, how do you satisfy it? And I said earlier, you satisfy it by having the witness in the courtroom, face-to-face with the jury, face-to-face with the defendant, presence of the jury, under oath. As technology gets better, and maybe some of you have done interviews like this all the way, we're starting to get technology that enables people to be in one place and interact with somebody as if they're in the same room. And so, for George's comment about a forensic analyst who's now moved from California to Florida and who's no longer available, I would leave open the possibility that maybe we'll get to a place where that person can testify from Florida when the technology is good enough that you're essentially accomplishing everything confrontation is designed to accomplish. But those would be questions about what satisfies confrontation, not whether a statement or a witness is subject to the rule. But I think there's some neat possibilities there. George?
Yeah, I don't actually have anything to add to that. Nick, did you have something in mind in particular asking that question? So I agree with what Jeff just said about technological solutions to this problem of no confrontation. We can create a confrontation from a distance, and I think that's a great prospect for the future. And I'll just to end on something wholly unrelated, but related to technology, and it's just so that you don't think that Jeff and I are always on the opposite side of every question. I fully agree with the work he did in Riley versus California that suggests that cell phone searches by the police should be subject to a warrant requirement. And that, I think, that technological related question, I think we're completely on the same page.
All right, would you join me in thanking Professor Fisher and Professor Fisher?